Unlisted matter today. What is the urgency?
The Deputy Commissioner set apart the land for the purpose of construction of path to my house.
Yes.
There's no pathway.
Yes.
And the Tahsildar issued a notice for demarcation of the land, but they are not demarcating the land.
Can't be done today, sir. Sorry. Where's the other side? You have not even mentioned.
So your leave is granted, I will not.
Not today, sir. Next, sir.
I don't want. And for
My lord, I beg to appear on behalf of the petitioner, my lord, in this case.
Yes.
My lord, it is required to apprise your lordship that how it came before your lordship today, my lord. My lord, pursuant to certain allegations, my lord, a criminal case was registered, my lord, with several sections, my lord. Out of all the sections, only 2 sections are non-bailable. One is of 2 years punishment and one is for 3 years punishment, my lord. My lord, I reside at Delhi. I took the matter, my lord, and my lord, I made an application before the learned sessions judge at Port Blair, my lord. My lord, the learned sessions judge, my lord, the running page number, my lord, the order is 23, my lord, where the learned session judge rejected my application as to anticipatory bail, my lord. At that point of time, my lord, I was residing at Delhi, my lord. I directly approached before the Honorable Supreme Court by making a special leave petition, my lord. And the Honorable Supreme Court was pleased to prima facie grant an interim protection in my favor, my lord. That orders, my lord, is in page number 26 and 27, my lord. For 15 days, my lord, I was granted interim protection, my lord. And with the liberty, my lord, to approach before the principal bench of the Honorable High Court at Calcutta, my lord. As at that point of time, the Honorable Lordship of the Circuit Bench at Port Blair was not in session, my lord. With the direction that, my lord, the High Court Legal Services Committee will appoint a learned advocate, my lord, to appear on behalf of the petitioner, my lord. In that score, my lord, your petitioner was approached before the High Court Legal Services Committee, my lord, and subsequently, my lord, the matter has been represented before your lordship, my lord. So initially, my lord, the principal bench also granted an order for further protection, my lord, when at that point of time principal bench was at Sisin, and subsequently it came up before your lordship, my lord. My lord, I am all along ready and willing to cooperate with the investigation, my lord. The allegation per se is, my lord, an outcome of a list published by the administration, my lord, of certain Bangladeshi immigrants who are allegedly staying at Andaman, at the area of Andaman administration, my lord. Purportedly, the allegation is that, my lord, that news came out and thereafter I published it by way of WhatsApp group and YouTube, my lord. And I lodged a complaint before the National Investigating Agency and before the SP concerned, appraising such facts. And, my lord, subsequently, the day I lodged the complaint, after 3 days, my lord, this case was registered against me. If your lordship be pleases, my lord, I may, my lord, walk your lordship through some documents, my lord. On the earlier occasion, my lord, I am a social activist, my lord, of administration under the jurisdiction of Port Blair, my lord. And I'm also a secretary of a party, my lord. I have represented in the MP election, participated in the MP election also, my lord. There are some vengeance, my lord, with the administration. I'm having some animosity, my lord. That is the actual crux why this FIR was registered, my lord. On the earlier several occasions, my lord, I have obtained the orders from the Honorable Supreme Court. The Honorable Supreme Court has on multiple occasions were pleased to grant me protection, as well as, my lord, police escorts has also been granted in my favor, my lord. If your lordship be pleased, my lord, kindly comes to page number
You're not
20.
cooperating with the investigating agency? Why you have
My
not?
lord, my lord, my lord, I am all along cooperating, my lord. I have lodged, I have represented, I have gave reply, my lord. What they have done, my lord, 10th of June, they have initiated the FIR. After 1 month, more than 1 month, on 17th of July, they issued the notice, my lord.
Really? Mr.
My
Roy,
lord,
where are
lordship,
you residing? Where are you residing?
lordship,
Where are you
my
residing?
lord, my old parents are residing at Port Blair, my lord, under the jurisdiction of Aberdeen Police Station, my lord. And I am residing with my family at Delhi, my lord.
You are appearing in this
My
court
lord,
on basis. I have seen you in the court, and in
my
many
lord,
cases you have said that you are
my
residing.
lord, as and when your lordship directs me, I came before your lordship, my lord. As
Don't,
and when your
no,
lordship directs me,
Roy, this is absolutely a wrong
my,
subject to make before this
my
court.
lord, my lord, I were present, my
You
lord.
don't live here. But in every petition, you say that you stay here.
My lord, I stay here, my lord. On and off, my lord, I have my wife and child, at Delhi, my lord. I am because, my lord, I am having certain difficulty to stay here, my lord, because of the vengeance, my lord, on the earlier occasions also. Police protection was granted by the Honorable Supreme Court, my lord. This is the magnitude of the vengeance I am having, my lord. Kindly considers that, my lord. Well, that is the reason, my lord, I could not stay happily at Port Blair, my lord. Subject to your lordship's correction, my lord, I have been to Bamboo Flat police station multiple occasions to cooperate with the investigation while I was protected. Multiple occasions, my lord. My lord, kindly sees my email. I have gave reply. I have asked, my lord, preferred a CRAN application as well also to apprise before your lordship that I have been at Bamboo Flat police station multiple occasions, but they are not ready and willing to take any statement from me, my lord. Only, my lord, to harass me. Anyway, my lord, if your lordship be pleased enough, my lord, your lordship can grant any condition, my lord, as per the sections of 482, my lord, your lordship can grant me any directs me for any condition, my lord, and grants bail, my lord. I shall be at duty bound, my lord, to comply with the directions, my lord. It's a very, my lord, allegations are not that serious, my lord, and it's a matter of administrative records also. Kindly considers that, my lord, no, 2 years and 3 years of punishment, my lord.
You're not even showing the FIR. You're not showing any document. You're just
My lord, my lord, I'm so sorry, my lord. I'm so sorry, my lord.
any
My lord
document.
comes to, my lord, page number 63, my lord. The relevant part of the FIR, my lord. The letter of complaint, my lord. Page number 63, my lord. My lord, the relevant part, my lord, page number 66. I'm so sorry. 66 is the, my lord, the 63, the FIR starts, and the alleged portion is, my lord, 66. If your lordship takes the middle portion of the FI of the letter of complaint, my lord, well, it is stated that it has the middle portion of page number 66, my lord. It has come to my notice that following a report filed by an officer, the veracity of which remains unverified regarding the alleged presence of Bangladeshi nationals at the masjid in Manarghat village. Mr. Manoj Pal took it upon himself without any lawful authority or role in law enforcement to record and disseminate a video across various social media platforms, including WhatsApp and YouTube, in the said video. Mr. Manoj Pal has openly accused the Muslim community of Manarghat of supporting illegal Bangladeshi immigrants. He claims that in Andaman Nicobar, the ground floor of every masjid is used for prayer, while the first floor is constructed as rented rooms where illegal immigrants reside. My lord. This is the allegation, my lord, against me. Pursuant to a document, my lord, which got viral, which was a report, my lord, by the by the Port Blair administration, my lord, where, my lord, a list of places, my lord, running page number 55, my lord, 54 and 55, my lord. Kindly, my lord, sees once
Where is the
a
publication?
little, my lord. Communication, my lord, page number 59, my lord. I lodged a complaint first. I lodged a complaint before the NIA,
Session court?
page number
Where is
59.
the session court?
My lord,
Sessions court, right?
Page number 23, Lord.
Sessions Court, I approached before the Lordship Sessions Court, page number 23, my lord. My lord, virtual hearing, little difficulty, my lord. Running page number 23, my lord. My lord, the reason was I did not cooperated with the investigation and I failed to comply 35 BNSS.
So did you cooperate with the 35 notice?
I shall all along cooperate, my lord.
The notice
Repeat, my lord, I repeatedly gave my replies, my lord, that I want to cooperate because there is everything is on record, my lord.
Have you record? Did you come here?
My lord, I was there, my lord, but I need to leave jurisdiction, my lord, because my lord, I have to attend my works also. I was there. I went to police station also. I filed it by way of an affidavit also.
Never.
Repeatedly, I went to police station.
Never.
I
Entire
went to police.
Constitution says you have never cooperated the state.
My lord, they will always say, my lord, they will always say that. Kindly appreciate. They will always say, my lord.
Mr. Roy, when you go there, there's a record.
My lord, my phone numbers,
Might
my
be
lord,
notice.
my lord, I shall comply, my lord. I shall comply.
You shall comply. Why should I grant you bail?
My lord, your lordship pleases, my lord. I shall definitely comply, my lord. I went there, my lord. My CRAN application. I have made an application, my lord. I took photographs in front of the police station. They can take my location also, my lord. I was all along there. I have also annexed my
What have you annexed?
stairs.
Hey,
My
Mr.
lord, not
Just making submission without showing the documents.
my CRAN application has been filed, my lord. That may not be, my lord, with your lordship's records, my lord, because it has been filed 2 days back, my lord.
The grant
But
application.
what I am lordship, my lord, that has been filed, my lord. Once I will urge your lordship to take once, my lord, the running page number 37, my lord.
And two. Yes,
Lord,
another crime.
my lord, I will beg before your lordship to come to once, my lord, page number 37, once, my lord.
Page number?
37, my lord, running page number 37, my lord. My lord, I am a social activist, my lord. I have no antecedent like this, my lord. I am a social reformer. I am trying to, my lord, fight against the corruption, my lord. My lord, kindly sees, my lord, page number 36, the bottom paragraph, my lord. I am reading, my lord. It's an order of the Honorable Supreme Court. Though we do not, page number 36, my lord. The bottom para, my lord, 7, paragraph number. Though we do not propose to go into the merits of the matter, taking into consideration the nature of allegation and further the communication dated 22/1/2024 addressed by the Deputy Superintendent of Police, so and so, we find that it will be in the interest of justice that the petitioner is provided a police escort whenever he travels to Port Blair. The Superintendent of Police District Headquarters, South Andaman District, is therefore directed to provide a police escort to the petitioner whenever he arrives at Port Blair, and the said escort to be continued with him till he leaves the Port Blair. The petitioner shall communicate the details regarding the arrival of the office of Superintendent of Police District Headquarters, South Andaman District, at least 3 days in advance before his travel. The said protection shall continue to operate till the disposal of the appeal filed by the petitioner before the High Court The special leave petition is so and so disposed of, my lord. On multiple occasions, my lord, Honorable Supreme Court has been pleased to grant me protection, my lord. My lord, the Honorable Supreme Court has also pleased, my lord, to grant me a liberty to approach before the learned trial courts to participate in the proceedings virtually. As, my lord, I am not getting any legal assistance from the legal services from the local bar association, my lord. But the Honorable Supreme Court has been pleased to direct the Tis Hazari District Legal Services Authority to render me legal services, my lord. My lord, these are the, my lord, reliefs I have obtained from the Honorable Supreme Court. My lord, kindly consider, my lord, the merits of the case, my lord.
Yes,
No, please, Lordship. Lordship, on 7th June 2025, Lordship, that day was the Muslim celebration, the Eid was there, Lordship. On 7th June, he got some information and made a video which was uploaded in the YouTube by this petitioner, Lordship. That video near about 25 to 30 minutes containing the timing, and it was totally directly to the harming the communal feelings. That was uploaded on 7 June 2025, Lordship. Then on 10 June 2025, that Majlis committee made a written complaint. And there was a huge gathering before the police station, Bambula police station, because that video clip showing direct to the defamatory to the communals. For that reason, law and order was break down. Some certain action have been taken by the police station, PS Bambula. On 10 June, FIR have been lost. For that reason, taking some information, Lordship, is the not offense, Lordship. Kindly see on the day of Eid celebration he has uploaded in the YouTube channel. That is the offense committed by at this stage. Next, after restriction of the FIR, Lordship, 41 a notice was issued, Lordship. 14-7. But it's the first 41 no replies in spite of receipt of 41 a, Lordship. Thereafter, what happened that that committee has written another complaint that this person is not doing alone this type of cases. Some persons are involved because there was a huge gathering in the police station by the Muslim committee. Thereafter, second notice was issued 41A. He also did not cooperate, did not come to the Port Blair. He has given a reply that I am residing in Delhi due to the long distance. I am unable to come to the Port Blair for cooperation. That is the second notice, Lordship. Kindly appreciate this part. Thereafter, thorough investigation was going on because the written complaint was filed at committee that behind this process more people are involved. For that reason, what happened after issuance of 41 second notice, we moved anticipatory bail before the session court, Lordship. Till filing the session court through a BC, he appeared, which was heard and which was rejected by the session court, Lordship. So since 7 June 2025 till second notice, he never cooperated with the investigation officer. He directly went to the Honorable Supreme Court. Thereafter, Lordship heard that what happened from the Supreme Court, Lordship. Here, Lordship, kindly appreciate when the police team reached to the Delhi for purpose of fair investigation. That occasion also he was absconding from there. From the Delhi he was absconding. The police team stayed there 60 days for interrogation of this accused person. On 17 or 18 days or so, when the police returned to Port Blair after getting interim protection from the apex court, very next day, he sent an email again that I am ready with the cooperation at Delhi because he knows he was following the police team. He knows that police already left. He got the interim protection. Very next day, sent an email that I am ready with the cooperation at Delhi. Thereafter, what happened? Supplementary affidavit he has filed, Lordship, kindly say, he stated in email that is page number 10, Lordship, of the supplementary filed by the petitioner. Page number 10. Kindly see, Lordship, he sent an email that I reach to the Port Blair. I reach to the Port Blair and make an arrangement for interrogation, me, Lordship. Kindly see, page number 10. But he never police station, Lordship, photograph showing some selfie from the main road in front of the police station. Kindly see the page number 10, then 11, Lordship, of supplementary. police station Bamuflat, he never entered lordship. Why police did not interrogate this person if he entered into the police station? So kindly see the entire episode since beginning, since 7 June 2021. Clearing showing that non-cooperation of this accused person since 7 June 2025. So cleverly he has done lordship. First anticipating before the session court, direct to the honorable apex court lordship, and kindly appreciate there is a cognizable sensitive matter lordship. Maybe the offence punishment is not more than 7 years, but what was happened kindly have to see. And till today, what we have done, Lordship, after uploading YouTube, the investigation agency filed a petition before the London Court of Chief Judicial Magistrate to obstruct him from the social media. That order had been also allowed by this trial court. He has deleted the entire YouTube. He did not hand over the mobile phone of the forensic examination. Still he is absconding, cleverly done everything that I am ready to cooperation, I am ready to cooperation, but he never came before this court. Lastly, last 1-2 months he is absconding. From Delhi also he was not found. The police could not interrogate the properly. Mobile could not be seized by the police agency lordship. And moreover, 21 cases are pending against him lordship. 21 cases. I have list that is use this type of things, comments against administration, against judicial officers, against everybody lordship in social media. For that reason, order have been passed not to upload it, this type of thing. So I seriously opposing the bail application. He reached at Port Blair lordship, but not only cleverly you have done photograph showing I was at police station, but he never entered in the police station. That is my respectful humble submission, lordship.
The petitioner has invoked the
What else, my lord, a petitioner will do, my lord? Going to, my lord, police station, giving them emails, my lord, stating that he is at Bamboo Flat police station, my lord, at Port Blair, my lord. They are reluctant, my lord, to record my statement, my lord. Kindly consider that, my lord. The photographs, rightly, my learned brother has lightly contended, my lord, that I have annexed everything, my lord, showing that I was all along present whenever the police investigating agency wanted me. Only, my lord, my presence was at that point of time when I was granted protection from this learned court and the honorable apex court, my lord. There is no wrong in that, my lord. I was granted with protection, my lord.
petitioner has,
And my lord, came before your lordship, my lord.
the petitioner has invoked the inherent jurisdiction of this court under section 482 of Bharatiya.
Lord, only one humble last indulgence, my lord. My lord, notice has been served after, my lord, 40 days, my lord. 37th day, my lord.
Sorry?
37, my lord, notice of 35-3 has been served upon me after 37 days, my lord. 10th, my lord, the FIR was registered after I lodged the complaint before NIA. 7th, my lord, I lodged a complaint before NIA, narrating this incident, my lord, that police is not taking steps, my lord, for illegal immigrants, my lord. 10th, my lord, FIR was registered after 3 days, my lord. Then on the next month, on 17th of July, notice was issued, my lord. They have not served me the notice within a week or within 14 days, my lord. I am grateful, my lord.
2023, bracket by BNSS, seeking the relief of anticipatory bail in connection with Bamboo Flat case number. Bamboo Flat Police Station 89 of 2025, dated 10/6/2025, for offences punishable under section 351(1), 351(2), 352, 353, 2, 356, 356(1), 356(2), 298, 299 of BNS 2023. ये यहाँ से ना एक बार पेज 63 से ना ये सेक्शंस देख लेना, चेक कर लेना ये सेक्शन यहाँ पे 356, 298, 299, ठीक है, ये सारे सेक्शन पेंडिंग बिफोर द कोर्ट ऑफ चीफ जुडिशियल मजिस्ट्रेट, पोर्ट ब्लेयर Full stop. The case of the prosecution is that a complaint was lodged by the Muhajiddin Juma Masjid Committee against the petitioner, alleging that he had uploaded certain communal videos. Full stop. In the said videos, the petitioner is alleged to have made statements indicating the presence of Bangladeshi nationals at the masjid situated at Mannargat village. Full stop. It is further alleged that the petitioner that the it is further alleged that the petitioner openly accused the Muslim community of harboring illegal Bangladeshi immigrants. Full stop. The petitioner is also stated to have alleged that while the ground floor of the masjid is used for offering prayers, the first floor is being utilized to accommodate the Bangladeshi Muslim illegal Bangladeshi Muslim nationals, illegal Bangladeshi Muslim nationals. Full stop. On the basis of the said complaint,
Immigrants, my lord. Illegal Bangladeshi immigrants.
anybody for the nobody's for the complaint. On the basis of said complaint, FIR number 29 of 2025 dated 10/6/2025 was registered against the petitioner at Bamboo Flat Police Station under the provisions referred herein above. Full stop. Thereafter, the petitioner preferred an application seeking anticipatory bail, being criminal miscellaneous number 49 of 2025, before the Court of Chief Judicial Magistrate, Port Blair. Full stop. However, by order dated 24/7/2025, the said application was rejected. The petitioner thereafter approached the Honorable Supreme Court by filing SLP number criminal 11902 of 2025. Full stop. By order dated 11/8/2025, the said SLP was the said petition was permitted to be withdrawn with liberty to the petitioner to approach the Honorable Calcutta High Court. Full stop. The Supreme Court was further pleased to grant protection to the petitioner from arrest for a period of 2 weeks. Full stop. Pursuant thereto, the petitioner preferred the present petition through the Calcutta High Court Legal Services Committee. Full stop.
I'm grateful.
Matter was mentioned before the principal bench at Calcutta, which, by order dated 22/8/2025, granted interim protection from arrest until the circuit bench at Port Blair takes up the matter. Full stop. It is the case of the petitioner that he is a law-abiding citizen and has been falsely implicated. He further submits that he has filed several public interest litigations in Andaman and Nicobar Islands. Full stop. He also points out that on earlier occasions also FIRs have been registered against him, right? FIRs have been registered against the petitioner. Full stop. He has drawn the attention of this court to an earlier order passed by the Supreme Court in SLP miscellaneous number 1051 of 2024, dated 1/3/2024, wherein the court had granted police protection
My lord.
to the petitioner on the ground that he faces threat since he had filed a public interest litigation against the interest of had filed a public interest litigation. Full stop. Learned counsel for the petitioner further states that he has been residing in Delhi with his family. Full stop. He states that he has got a. How old is your son?
Well, it's 14 months.
14-month-old son. And states that he has been hounded up by the local administration for filing various public interest litigations. Full stop. He further states that while eliminated 11/8/2025 and 13/8/2025, he informed the IO investigating officer that he is willing to cooperate with the investigation through video conferencing, and that his statement may be recorded from any police station in Delhi. Full stop. However, no response has been received in this regard. Full stop. He has further filed CRAN 1, wherein he had annexed pictures to show that he is ready and willing to participate. Pictures standing in front of the police station to show that he is ready and willing to participate in the investigation. Full stop. He had also written a letter dated 4th September 2025, wherein he has stated that he is present in Port Blair and is ready and willing to record his statement. Are you here today?
My lord, today I'm not here, my lord.
When are you
Today I'm
coming?
at Today I'm at Calcutta. Whenever your lordship directs, my lord. Only, my lord, some time for flights, my lord. It's expensive, heavily expensive, my lord.
And participate in the investigation in the interest of justice. Full stop. Learned public prosecutor has strongly opposed the prayer for anticipatory bail, it is submitted that, despite service of notice, the petitioner has not cooperated with the investigation. Full stop. On the contrary, it is alleged that the petitioner continues to upload. He's still uploading? He continues to upload objectionable videos on social media. Full stop. It is further submitted that viewing such videos has incited communal tension and unrest in the area concerned. Full stop. According to the prosecution, full stop, the petitioner, you need custodial integration. For what? Yeah, he states that custodial integration of the petitioner is imperative. Full stop. Hence, he prays for rejection of the anticipatory bail. Full stop. This court has heard the argument advanced by the counsel for the parties and has examined the documents. Even after receiving interim protection from arrest, the petitioner has not placed himself physically at the disposal of the investigating officer, and on the material on record continues to upload. Why are you uploading still?
My lord, I'm not uploading nothing, my lord. How, my lord? It's absolutely, my lord, blatant, my lord. I have not uploading, my lord. A case is pending. I am before the Honorable Supreme Court.
From the case diary, show me
My
what
lord, Supreme Court grants me protection. I will be having, my lord, guards, my lord, to upload, my lord. When I am a social activist, my lord, I always come before your lordship to seek, my lord, relief. I won't having, my lord, that audacity, my lord.
the first upload after 10th of June.
My lord, I lodged a complaint before NIA on 7th of June, my lord. Apprising, my lord, what material I have received from the social media. And they starts a case, my lord, after 3 days against me. My lord, I believe that it is my responsibility and duty, my lord, to be with the administration, my lord. And no illegal acts have been committed.
No, but this is not showing that he has put anything on record.
Never, my lord, never. Never. No, my lord, absolutely not, my lord. Absolutely.
Can you keep quiet? The problem of asking. I'm not asking you any questions.
My lord.
Yes.
Second time, threatening.
Threatening. You are saying he has uploaded. Where has he uploaded?
No, that threatening part is uploaded.
Threatening is threatening who?
Lordship. To
Is
the
threatening who? Your officer.
Lordship.
Officer.
No, Lordship. You uploaded it just. Regarding communal, second time, no upload. As per the case diary.
क्या लिखा है? Allegedly objectionable videos from Delhi, which according to the prosecution has नहीं, इसको चेंज करो फिर क्या फिर बताना ऊपर से बताओ क्या लिखा है इवन आफ्टर रिसीविंग इंटरनल प्रोटेक्शन का क्या has not placed himself physically at the disposal of the investigating officer and the statement made by the counsel for the prosecution that he continues to upload objectionable videos is not found from the case diary and is a wrong statement. Full stop. It learned counsel the is a wrong statement. Full stop. The petitioner, since the petitioner has been filing several public interest litigations and has been pushing the administration to the brink for on the brink, he faces serious resistance from the administration and even on earlier occasion he had been granted necessary protection from the Honorable Supreme Court in view of the public interest litigations which he has preferred before this court. Full stop. The allegations in the FIR are of uploading a video which the petitioner states that how have you uploaded those videos? Have you made it? Did you make those videos?
My lord, only my lord, it was disseminated by some small press media, my lord. I just circulated in the WhatsApp group, my lord.
So you have not made the video.
My lord, maybe my lord, some statements like this that this has been already the administration has already found some material on illegal immigrants, but they are not taking any steps. This may be, my lord. Exact words I don't know, my lord.
Learned
I
counsel
have to check.
for the petitioner states that he is ready and willing to cooperate in the investigation. He further states that he had received the notice under section 35 notice, right?
My lord.
After a delay of 37 days. Full stop. Full stop. In view of the facts, this court is inclined to grant anticipatory bail to the petitioner on the above said terms, on the said terms, on the said conditions. Full stop. The petitioner shall cooperate with the investigating agency. Full stop. The petitioner is released on a bail bond of rupees 10,000 to the satisfaction of the chief judicial magistrate. 10,000 plus 2 sureties to the satisfaction of the chief judicial magistrate. He shall cooperate with the investigation. What more conditions you want?
Me to the investigation.
To report before the investigating officer every fortnight, once a month.
I
My lord, extremely my lord, burdensome, financial burdensome, my lord, from coming, my lord. Virtually, my lord, I am ready and willing, my lord, anytime.
Once in a week will be, you come and stay here for a while. Your parents are here.
My lord, my lord. My lord, after some days, my lord, just I left, my lord, after, my lord, price of the fare tickets will be little high, my lord, if I
That's all.
come suddenly.
Petitioner undertakes to meet with the
I'm
investigating
grateful.
once a week.
Grateful,
Once a week. Get the condition,
my lord.
2 months, whatever it is.
Lordship.
Once a week. Full stop. With the above direction, the present application is disposed of. Anything else?
Not to upload this time.
The petitioner undertakes not to upload any videos with any communal tenor or any video which hurts the sensitivity and communal harmony of any religion. Full stop.
Not to leave this island without prior permission.
That is not. Once a week he's meeting you, there's no point of that. That is too restrictive.
Alright.
Every fortnight, kar do. Once it's too much.
My
Fortnight.
lord, it will be extremely burdensome, my lord.
Mr. Roy, every fortnight he'll report.
My lord, 1 month, my lord, subject to your lordship's correction. My lord, practically it will be very difficult, my lord. Kindly consider, my lord.
Once a month.
I'm so grateful, my lord. I'm so grateful.
Grand one is also disposed.
I'm so grateful, my lord. Malaj, I apologize, my lord, for my lord, intervention, my lord, why your lordship dictating, my lord. Only one, my lord, humble one indulgence, my lord. Not before the sessions, before the sessions could, my lord, the bail was initially rejected, my lord. Instead of, my lord, Chief Judicial Magistrate, my lord.
Bail bond has to be furnished before.
Yes, the bail bond is chief judicial. He's saying it was set aside. That sessions.
My lord, initially, my lord, recorded, my lord, CGM passed the order of rejection, my lord. That will be sessions judge at court. I'm grateful, my lord. I'm extremely grateful, my lord.
Next.
I'm deeply honored.
For the respondent, madam,
Yes.
I'm raising a preliminary objection.
Yes.
And protection is that, madam, my anticipating bail application consists of 45 pages. That was not enclosed along with the application. Number two, madam, the Leonard Chief Judicial Magistrate madam granted regularly.
So then what survives? Why this? What is there in this petition? Who is appearing for the petitioner?
I for the
Yes.
for cancellation of bail also. It was
For
granted
cancellation.
additional.
But now regular bail has been granted.
Lordship is surrender. Lordship true, but by your supplement, I may be leave granted to file that bail application.
For what? Now nothing survives.
Lordship is. But
Like now you will ask for cancellation of the regular bail.
also not regular bail. The anticipatory bail was allowed.
He's saying regular bail has been allowed. Give the copy to him. Just check it.
Considering that the accused person has been granted anticipate by the United States, his prayer for regular bail is allowed.
But even the Lordship, you may be granted to file at least that part to bring in the record. Because it's a huge financial irregularity case.
Learned counsel for the state seeks and is granted liberty to file. What is it? Supplementary.
By enclosing my application.
Lordship.
Supplementary affidavit bringing on record the entire documents on record.
Obliged.
List before the next available second. Same order in other cases also.
Alright, so the accused were discharged from the division of corruption and Lordship. I have challenged that discharge.
Anybody appearing?
Lordship, I am service not affected upon other persons. One is there.
You have to.
Lordship.
Learned counsel for the petitioner seeks time to serve upon the other parties, other respondents. List before the next available supplement. Yes. Not today. Tomorrow, do we have a court? At the request of the learned counsel of the parties, let this matter be listed before the next government, sir. Mr. Mishra was there in this matter. Anyway, let it be next circuit.
That's 5, 6, and 7. I have different applications for review.
Yes.
My lords, I am appearing online, my lords, in item 7. The host has disabled my video, so I'm not able to switch my video on, my lords. I'm in item 7 for the petitioner. My lords. In fact, my lords, pursuant to the mentioning on the last date on the 25th, we were served with a copy of an intervention application, and we are in the process of drafting the reply because we have some preliminary objections to the maintainability as well as on the merits of the application, my lords. In fact, we are in the process of just finalizing our reply, which we would file in a week's time, my lords.
You are appearing for, Mr. Bashanda?
My lords, I'm in item 7 for the petitioner, my lords.
Item 7 for.
Yes.
Yes, Mr. Kabir.
This matter pertains to a situation
Yes.
where there is a company which is essentially dealing in cryptocurrency. Now, this cryptocurrency, put very simply, is a set of tokens.
Yes.
The allegations in this case are something which spans the globe because this gentleman was setting up these tokens and he was attracting investors.
So who are the petitioners in, so this is item,
Now, first of all,
just a minute, Mr. Kabir, wait a minute.
5, 6, and 7.
You are the petitioner.
No, I'm in 5 and 6.
Yes.
My younger brother is in item number 7, and also the other brothers appearing online ballots.
All right.
In the present matter, ballots, while he's filed an application to complete,
Yes.
first and foremost, ballots, the maintainability itself is in question. He served it upon us. We would file our replies accordingly, ballots, insofar as his application is concerned. Insofar as the main matter is concerned, where
Yes.
my learned senior brother has no role in that, because the primary complaint, the de facto complainants council is also present before this court matter. There's an MOU that has been filed before the previous circuit bench in the same matter. The compliance of those MOUs are in progress, and whatever the financial transactions were, the payments are being returned as per the concerned MOU is concerned.
He's also one of those person
He's
who.
not, so the contract is entirely different. His contract is only with respondent in so far as the petitioner in item number 7 is concerned. And he's pulled all of us also into the matter, whereby there is no FIR, there is only a primary complaint. If at all we had to go, the due process of law had to be followed. This is not the court where he can file an impleading application. He has to follow, yes, it's a fresh cause of action, he has to file a separate complaint. He can follow, if the concerned police station is not taking the complaint, let him take the recourse as held by the Honorable Apex Court in Prakash Srivastava.
Yes.
Leading in a 482 matter where it's a the de facto complainant is there, the other petitioners are here, where the matter is being has been settled by way of MOU, and as per the last orders in the previous circuit bench files, the court has given no coercive action, and there is no stay on the investigation per se. People are joining the investigation. We are cooperating with the investigation. There is no way that we are saying that we are running away.
Good. Yes, Mr. Kabir now.
Madam. So this particular company,
Yes.
it goes by different phases. So the situation here is, if your lordship sees the list, item number 5 is filed by Azar Enterprises,
Yes.
and the person behind it is one Mohammed Wasim and one Latifa Banu. They are of Andamans. Number 6, Sierra 34 is one Vaibhav Gupta. 7 is one Ravindra Kumar.
Yes.
Now, what they do is they put out to different investors different proposals.
Right.
These proposals are made to appear as if there is a project for launching these tokens. They make it appear as if they have various investors. They put out assurances as to who all are investing with them. There is something which is a cryptocurrency stock exchange, practically speaking, called Binance. They put it out that they're listed there. They give all sorts of assurances and promises. Now, on the basis of this, they collect funds from people across the globe. These funds are channeled through different corporate entities, and behind the corporate veil, you do not know who is where. Now, in this situation,
Who are you?
I am one of these investors. Now, what has happened, to simplify things, this is like one giant Ponzi scheme. It's just with a touch of techno digital jargon.
Yes.
Now, the situation that has happened here is one person who managed to trace this set of connections files an FIR in Anticipatory.
Yes.
When this FIR is lodged, Pandot will see if your lordship is taking up the application in 33, my grant along with that.
Your CRAN is in
Pandot, in all three applications, which are the revisions for
CRAN 2.
40,
CRAN 2.
grant.
Yes. Yes.
So if I can beseech your lordships, I'll just take your lordships through the documents. So first of all, how we come into the picture is at page 88. Now, while my lordship friend makes a submission that we are a different issue, different cause of action, etc., etc.,
Yes.
the crime that has occurred and the offences that have been committed are one set of offences which affect a large group of people.
Yes.
What these gentlemen have done, acting collusively, is come up before the court with one complainant, the person who was the original complainant, and they come here and they say, oh, this is just a civil dispute. We've settled things with him. The court has not demonstrated the full nature of the situation. And on the basis of that, that complainant purportedly appears. Now, when he appears, he says, oh, I've entered into a settlement, let the matter be quashed. Now, the difficulty here is, I am a victim as defined under 2WA of the old code and as defined under the BNSS as well. As a victim, I have a right to participate in the proceedings at any stage, in any place, whether they make me a party or not, even independently. This is the law laid down by the Supreme. Now, all the other victims in this case have suddenly woken up to the fact that by bringing the complainant here and offering him money, the entire case is sought to be.
So how many victims are here?
No, I'll point out your logic. Kindly come to page 18.
And why you are not taking your own legal recourse?
I'm telling your logic. Page 18.
Yes.
So your lordship will get the relevant portion at page 91. On the 5th of August, we received this email from the SPCID. Now the SPCID says that we are investigating into this matter. An FIR has been registered. And in this regard, we have come to know you are also an investor in Self-Chain tokens. For further queries, please contact us and provide your contact number. Now, the dates are very interesting. This is happening on the 5th of August. As soon as I realize this, effectively, I am a witness. So at page 88, I respond. Your lordship will get that email dated where I detailed the entire situation. Now, on the basis of this situation, there were telephonic conversations with the police authorities who initially had held out a situation that the similar thing to what my friend is saying, that if you have a problem, file a separate FIR. Thereafter, my lord, we have to know again from the police that this allegation is something which doesn't cover one or two people. It covers a lot of people. And we have now received this email on the 3rd of September that the matter has been incorporated into the ongoing investigation. And this is the latest of the emails.
Yes, you are ready for the state.
Now the police has actually started looking into the matter and has found it is a huge scam where this is covering, so far as the complainant is concerned, $8.5 million. As far as I am concerned, $500,000, and the amounts go on and on and on. Now the difficulty is this is not something as simple as just an agreement which is not performed or some civil sort of thing. From the very inception, there was an intention to cheat, to misappropriate. The total amounts involved in this have now gone north of $150 million. Now, this is something which at the regulatory level, because cryptocurrency is not technically not illegal, technically not legal. It's in the sort of gray area. Other regulatory authorities are also now looking at this because of the impact this has in the economic sense as well. Now, this particular case is one where by coming up before this court and showing one person and one particular allegation of settlement, they have obtained a blanket order saying no persons will exceed. Now, in this background, the court here takes up 5 matters. The first matter, one will kindly take up my application, I have indicated it there. And that is why I said the dates are important. Paragraph 38 at page 19.
Where are you reading? Which one?
My lord, my application.
Your application,
Supplementary
page 90.
Supplementary application, the improvement application.
Page?
19, para 38.
Yes.
So on the 13th of July, this FIR is registered. On the 29th of July, 2 revisions are filed. One by Azza, one by Vaibhav Gupta. The next day, Vaibhav files an anticipatory bail application and the revisions are withdrawn, are adjourned. Now, on the 31st of July, the anticipatory bail application is adjourned. On the 1st of August, now they had filed matters in such a way, there were matters before both the benches. So one set of matters is released from this bench and moves to the other bench.
Yes.
Now, before that bench, Ravindra Kumar comes up on the 2nd of August with his CR. On the same day, the application is listed, and I will point out here, just to digress slightly, that these applications are not maintainable in their current form. Now, on that day, the applicants as well as the complainant's lawyers appear and say a settlement is being worked out. So, therefore, kindly grant us an interim order. An interim order, a blanket order is granted on the 2nd of August.
Yes.
Now, on the 3rd of August, Mohammed Basim, who is a petitioner in one of the CRRs,
Yes.
he is arrested. In the process of his interrogation, on the 4th of August, they come up here and they say, well, everything has been settled. So there's no difficulty any further. And Mohammed Basim takes up an application for bail the very next day on the 6th of August.
Yes.
On the 7th of August, the bail application is adjourned and there are prayers made for filing supplementary affidavits so that the memorandum of understanding can be brought on record. This MOU comes on record and on the 8th of August, the bail is allowed without any sort of examination of the merits. And as far as the 3 revisions are concerned, these blanket orders are extended. Now the difficulty arises because we have no knowledge of any of this, but if your lordship sees the dates, what becomes interesting is that all of this happens by the 2nd of August. Now we come to know this from the police through that email, but we are not aware that these are the situations going on in court. Now, first and foremost, my lord would kindly take up the main CRR in 33.
Yes.
Kindly sees the first page, the reverse side. I've had the opportunity to inspect the records. This application could never have been filed. How it was accepted for filing, how it was listed, are questions someone has to answer. No leave was taken, no leave was granted. In a complete violation of the rules and procedures, this is filed, listed, moved, interim order. And this is the same for all. Number 2.
No, but it could have been filed in the register and listed. What is the difficulty?
No, ma'am. If this was a situation as per the staff reporter's endorsement,
Yes.
either leave had to be taken, Marot has had occasion to deal with this.
Yes.
Leave had to be taken and granted and undertaken furnished, and it would have been filed.
Right.
Or this would have remained defective. It could not have been listed. So this is the first part. So these applications come on board. There is a technical difficulty, but they come on board. Now, once they have come on board, this memorandum of understanding is brought on record to show that there is a certain this thing being reached, settlement being reached. Now, my lords, would kindly come back to my application for a moment. Now, so far as locus is concerned, let me show your lordship one by one my involvement in this situation. So at page 33 to 36, in the interest of full disclosure, I have given the documents of my company, my memorandum of association, my articles of association, everything to do with my company, which extends all the way up to page 59.
Yes.
At page 60 onwards, I have provided the copies of the communications which were there with this gentleman called Mr. Ravindra. At page 62, your lordship will get the details of the transactions. This was the first set of transactions, $200,000. Now at page 63, your lordship will get again the assurances being made. Page 64, further assurances. Page 66 is where names were being dropped, that these are the people who have invested, and these are people who have very, very strong credentials in this industry. At page number 67, I was provided the calculations and the value of my money that I have put in, and the assurance of staking these tokens and earning against them. Page 68 refers to the agreements that were entered into, just in case they say that there are no agreements and I have no locus. Your lordship will get it beyond that at page 71. And then the assurances with regard to the listing on Binance is at page 72. Now the second inducement occurs at page 73. I transfer another $200,000 at page 74. Now in this background, I suddenly come to know of the sheer vast nature of the scam at page 75. Now this is all over the internet. And I suddenly realize that there is a major problem. So I get in touch initially with Ravindra. Ravindra goes underground. My next point of contact is Mohammed Basir. He responds initially, then he goes underground. Now the money is being channeled from one to the other. This is why interrogation, intensive interrogation, and investigative methods using digital tracing, necessary forensic methods is so very important. Now, in this background at page 81, I cause a notice to be issued. At this point of time, I'm still unaware of the scope of what is going on. So I issue a notice. I detail the entire background of the relationship with Ravindra and where my money has gone. And I ask for restitution.
So are you only investing with Ravindra or any other?
My lord, my funds have been paid to Ravindra, and from Ravindra, my funds have moved on. This is what I have been told directly, and which I have to place before the
Ravindra
investigation.
is in which item?
My lord, item 7, I am appearing for Ravindra, my lords. I am appearing for Ravindra, and after Mr. Kabir's arguments, I would like to respond, my lords.
So Ravindra is in the third matter. Now Ravindra is a person whose company is again an offshore entity. But his company is the alter ego of Azam, which is the first of these traditions. And the different persons associated along the way are all connected because all of these things are done sitting in a computer, in digital space. So a username, it is very difficult to put a face to a name to say, I interacted with so-and-so, where the money has gone on, this entire trail, the entire money, this is all a subject matter of investigation. Now, what is the difficulty here is, the moment the investigation in this case starts, then this whole
sort of tangled ball of wool emerges, and now each strand is coming out. In fact, your Lordships will see that the police will have in their records, there are a total of about 100 to 150 investors who have been contacted and asked to provide the details of all the transactions so that the police can understand where the money has come in and where the money has gone. Now, at this point of time, the investigation has barely got off the ground. Now, the difficulty arises when a revision is filed with only the complainant as a party, which technically they can do. But the difficulty is when you have many other victims in one transaction, in one set of offenses. Now, all of those victims who are affected stand to suffer a serious prejudice simply because the complainant says, well, I'm satisfied, let the case be quashed. So, on merits, and so far as this entire quashing application is concerned, this is something to come to later. As far as I am concerned right now, what is my right as far as the victim is concerned? So the law laid down by the Supreme Court is very, after Jagjit Singh's case, when I place the decisions as necessary, the right of a victim to enter any proceeding.
But he's also not denying your right. He says he'll file his reply.
No, the difficulty here is that he may file his reply to my impleadment application. But whether my impleadment application is maintainable, not maintainable at this point of time, only two things are to be seen. A, am I a victim of this offense? If so, my right survives, irrespective of all the procedural matters. So my right to be heard, so far as the revisions are concerned, that right still survives in terms of the Supreme Court orders. Now today, if they come up with a reply and they say that no, this application is not maintainable, he is not a victim, whatever it is. But those things on merits are something which he can argue later. Today, as far as this application is concerned, the police is in a position to say whether I am a victim or not. If so, and if my entire the offences to which I have been subjected are part and parcel of this entire picture, then why not I have a right to stand here and address the court? This is number one. Number two, so far as the complainant is concerned and the agreement reached is concerned, my lord, again I've inspected the records. I am yet to find a Vakalatnama executed by the complainant. Now the complainant has appeared on several occasions. The entire situation is one where the complainant has arrived at some sort of a settlement. The records don't contain a vakalat. Now, assuming that the complainant is appearing and there is a vakalatnama somewhere, again, the situation here is that as a victim, my right of hearing has also to be seen in context. Now, in this background, Mr. Vaibhav, who has filed an anticipatory bail application, never moved. That is in the list today as item number 19.
Yes.
Your Lordship will find on the earlier occasions in that anticipatory.
He's not pressing it.
Money. So
I'm appearing in the matter.
Yes.
Well, if my learned senior brother is done, I may just have.
No, he's not done.
Now, so far as the MOU is concerned, my lord, I was surprised to find one thing. If your Lordship takes up the supplementary affidavit filed by them, the MOU seems to indicate
Yes.
the MOU seems to indicate three things. If your Lordship takes up the supplementary affidavit,
All other cases, complaints, disputes.
the MOUs, my lord,
Page 4.
are dated 7th of August 2025.
Yes.
Now, my lord, will kindly see who the first parties are.
Yes.
For all that they say, they are not connected to each other and nothing is common to them. The first parties are collectively Mr. Ravindra, Mohammed Wasim, and Webb. So there is an admission of a joint responsibility and liability. Thereafter, if your Lordship sees, the second part is named
Dutch consulting.
Mohammed.
Yes.
That is the complainant, Mr. Kukreja.
Yes.
Now, what is very strange is in the recital,
Yes.
whereas A, B, that the parties have now, they wish to amicably resolve all the issues, claims, disputes, including civil criminal litigations arising out of the above matters, without any admission of guilt or liability from either parties, without prejudice to the independent claims. to a structured payment, etc. But what is important is on the next page, if your lordship sees. One is where they agree to pay $8.5 million, $8.3 million. Two is the method of payment, 9 tranches. 3 is what is important.
Yes.
The second party accepts the settlement arrived at under the MOU as a full and final settlement of all claims and liabilities for Dutch Consultants Innovations Limited. And further other pool owners and their investors or individuals shall be settled by the first party.
This is what I said, now, Mr. Kabir.
My lord,
Para 5 on page 4.
my lord. Para,
5 on page 4.
my lord, I'm sorry, I have 34. So the page numbers are not matching.
Para 5.
My
The
lord,
second party also undertakes to close all other complaints, cases and disputes initiated. Probably
my lord. Para 5 at the next page. Now again, this is the complaint. Now if the complainant comes and says, I'm closing up everything, I'm taking my money and going. The offenses don't evaporate. Now the law in this regard is very, very clear. First of all, your lordship will cast my lord's minds back to 2007, 8, 9. Mother Mohan Abbott, Nikhil Merchant, that entire line of judgments, where settlements were arrived at, and the court said there's a distinction between compoundable offences under the then 320 CRPC and non-compoundable offences, which you arrive at a settlement. We will see 3 conditions. Number 1, the litigation has no complainant is not going to come and say anything in court. So the litigation is a dead duck, lame duck. Number 2, that it does not affect in any way public policy or public at large. And it is something which is an internecine dispute between 2 parties. Number 3, it is inherently civil and has a civil flavor in nature. Now, this law went through many years of testing in the Supreme Court until ultimately, I think, we came up with Gyan Singh, and thereafter that law has further been clarified by the Supreme Court. So, your lordship would find perhaps my learned friends relied on certain decisions where a civil transaction is there between a bank and a customer or whatever it is, and the court said, well, this is inherently civil in flavor. This is something where a compromise means nothing is there. This case is not such a case. So in this particular situation, in fact, there's a category of judgments which demonstrate an exactly different picture. So far as the merits are concerned, I'll come to that later on separate this thing. But here, the difficulty arises that the moment this memorandum comes into play and the moment this FIR is quashed, that is the attempt. If your lordship sees the earlier orders of this honorable court, none of the assistance that should have perhaps come to the court in the larger picture was there. The submission is repeatedly, it's a civil dispute, it's a commercial transaction, there are 2 parties.
That suits both the parties, so why
Madam, that is why at this point of time, it is so imperative that I come into the picture as a victim to demonstrate what is the larger picture.
But what about the state? Who's investigating it?
Fiction going on the basis of.
So what do you say? They are victims? The impleaders here? Ask the investigating officer. What is the rule?
If today the.
I will hear you. I will hear. I mean, no hurry.
See, on the basis.
You
of
just have to sacrifice your lunch, that's all.
Second, one complaint received from this person during investigation after registration of the person. So at that,
What is your investigation today? As of today, are they victims? They have been defrauded?
it's a OTC scam that is not involved till today. The victim is not involved till today, as per the OTC, because there was one document have been received by the investigation agency that is regarding some other case. As per instructed by the
So what is he saying? That they are still not victims?
Lordship, they are saying at this stage till today,
Hmm.
in this case, he is not victim.
He is not a victim.
He is not. I have been instructed
Very
by
good.
the inspection.
Yes.
This is a classic case, as we quote from Bhagavad Gita, Ashwadhama Gajomrita. I'll tell you why not. Now, my lord, let me go back to their affidavit. My lord, on page 68 and at page 81, where Khihar and company issues a notice, Typically in a cryptocurrency transaction, there is something called as a
Yeah,
simple
Mr.
agreement of future tokens of SAP.
Yeah, Mr.
I'm Ramakrishna. Well, they have, there's a SAP. Well, beautifully, while they have drafted this entire affidavit, they have not annexed the SAP at all. The reason why they are not annexed the SAP is because the concerned SAP specifically casts a jurisdiction in Singapore between a company registered in British Virgin Islands, which is the company of his client, and Mr. Ravindra, which is registered in Singapore with a jurisdiction and an arbitration clause in Singapore.
Arbitration has got nothing to do with this.
No, let me explain. Well, once there is a SAF, and this is a entire future tokenization.
But we are not concerned with the SAP, yes, sir. We are concerned with.
Let me differentiate. The concerned case for which all of us are standing, and the primary FIR, which was lost by
One more question. We can quash it?
Lordship.
No further investigation required.
Lordship, initial stage of investigation, second complaint received from that person. We have to verify it.
Oh.
Till today, Lordship, some correspondence made, only one document has been received. At this stage, not Lordship.
Why civil dispute?
Lordship,
No.
Lordship, at this stage, I again respectfully submitted. FIR is a not encyclopedia of an entire episode, Lordship. Let the investigation agency investigate the case. Can it become that it is a civil dispute? There can be action FIR will be submitted, Lordship. But not at this stage. Not at this stage, initial stage.
Yes, Mr. Srinivas.
Well, now, insofar as the entire voting allegations, everything that he made, the item number 5 and 6, first and foremost, I would like to correct my learned brother on the facts that insofar as Mohammed Wasim, on 3rd he gets arrested, 4th we move a regular bail, the police custody is sought by the concerned investigating agency, he stays under custody for 3 days. After that, the learned IO who's standing here comes and makes a mention before the concerned CJM court saying that no further police custody is required. He may be sent to JC. He's sent for JC for 1 day. Subsequent to that is when the anticipatory comes before the previous circuit bench, and the learned lordship is pleased to grant the anticipatory bail for whatever conditions. Now, my lord, insofar as the MOU comes on record, the de facto complainant is here, as counsel is here. The MOU is placed on record pertaining to the fact that these are the terms and conditions, these are the payment returnables. It's a financial transaction. The financial transaction is being returned as per the MOU. The terms are categorically envisaged with. And as per those terms, as and when the MOU is concluded, is when the quash was to happen. For X number of trenches is when they would not object to it. Till that time, only no coercive action was to be sought for. Insofar as Section 409 is concerned, which was also the question that was asked to us by the learned coordinate bench in the previous circuit, we categorically said that as per Gyan Singh, the matter may be stayed. The learned judge was not willing to stay the matter. No coercive action was sought in that manner. Investigation is still on. We've cooperated with the investigation. So far as Mr. Vaibhav Gupta is concerned, he joined the investigation yesterday and day before yesterday. He's appeared before the IO. Insofar as Mohammed Wasim is concerned, they themselves have given a statement that he's joined he was arrested, he was in police custody. Mr. Ravindra joined the investigation for almost 1.5 weeks. And after that is when the concerned terms were reached. Even today, the MO is in subsistence, the payments are in progress. And while all of us appeared online on the last occasion when the matter was listed before my lords, we also made the same mention. We never asked for stalling the investigation.
Today the investigation is on, as the state says that they need to investigate further.
MOU has to follow.
MOU will see whether it has to follow or not. It's too early to say whether MOU needs to be followed or not. As far as he is concerned, we will allow the application. You file it.
My lords, may I make one respectful submission with your kind permission?
Yes, Mr. Pachanda.
My lords, firstly, my lord, it is an incorrect submission, my lords, that the intention to defraud and cheat was right from the very beginning. If my lord peruses page 83, my lords, of the application, that is the legal notice sent to me.
That is for the investigating agency.
Yeah.
Right now, we are not.
So my only request is, my lords, this application has come up for the first time. May issue notice. I'll file my reply. I'm in the process of filing it in a. May issue notice. It can be kept in 2 weeks, my lords. I have no difficulty, my lords. I'm saying, my lords, issue notice.
Just one submission. Because in the light it is going, it will require certain arguments at length.
Very good.
The length has to be shifted with regard to the collusion, the way it's been demonstrated by the council. There's no collusion involved. He is completely determined, governed under the category of the self-chain, which was the composite, different, altogether different company floated by Mr. Ravin, which is at item number 7. Whom I love to
Tell him to meet him also.
Yes,
We'll have a
that's
new-
what it is.
New MOU also.
That's what it is, and it should have happened.
That
That is what should have happened.
That's not for you to
No, in his legal
decide.
notice is admitting, I will take all civil and criminal actions.
That's not for you to
Nothing that.
decide, sir.
You can't keep on sleeping over your right and come before a party stating
But
that
the
collusion.
complainant is making these submissions.
No, I'm not making, because you have placed a collusion allegation.
The complainant. is
You are getting
supported
hold
to
of,
accuse.
you are getting.
Sir, why are you getting?
I don't understand.
This is not your, this.
No, the allegation.
They should be more worried. You're not going to jail, are you?
Worried, the collusion, it's been shown as if the complainant is colluded.
No, he's
No,
not.
I
He's not
never said
saying
so.
that.
I
He has
never
not,
said
no,
so.
he has not said that. He is
Never
saying
said
that I am also a victim.
Yeah,
The entire argument is not against you,
Yes.
against the accused. No, sorry, he's not saying that. Not at all. He's saying that you are one of the complainant and he is also a victim, so he should also be a complainant. That's what he's saying.
And Malos, if I may just submit,
Yes.
so far as his allegation that he made on the MOU. Malos, there are.
I'm not giving any finding to them.
No,
No finding to them. I'm not saying anything. At this stage, I'm not saying anything. I take down. Grant to learned counsel for the petitioner. Learned senior counsel for the petitioner, Mr. Deep Cham Kabir, has moved an application. What are your prayers?
Madam. Your lordship kindly sees page 29. A, to allow me to be added as a party.
Seeking,
B, service.
seeking direction for addition
C, a detailed affidavit in opposition.
of the petitioner as a necessary party to the present petition. Full stop. It is the case of the applicant, learned counsel of the applicant, operation. It is the applicant, learned counsel of the applicant. It is the case of the applicant that he has suffered huge financial losses due to fraud and misrepresentation by the accused person. All the accused person or accused person, Mr. Ravindra?
So far as this is concerned,
The
that
accused person, all, you are alleging all three by the accused persons. Full stop. He states that he had made certain investments and the same has been defrauded and that he has been defrauded with those investments. Full stop. Learned counsel for the accused party, Mr. Srinivasan, states that the applicant, the present application is not maintainable and that the applicants have not suffered any pecuniary losses, any monetary losses. Full stop. He states that the allegation made by the applicant is incorrect. Full stop. He further states that an amicable settlement has been arrived into by the petitioner and the accused persons on 7th day of August 2025. Full stop. He said memorandum of understanding has been placed on record. Full stop. He states that he shall file his reply to the application filed by the applicant. He seeks and is granted how much time? 4 weeks time. 4 weeks time to file his reply to the application filed by the applicant. Full stop. Reply to the said, reply if any, within 2 weeks thereafter. List after 6 weeks. ये बात-
My lords, just one request: if the interim order may continue till the next date, my lords.
Just learned counsel for the state states that you don't need their custodial integration, right? No custody.
Perceive still order have been passed. Perceive not to take perceive
Not-
still order has been passed.
Yes.
So I cannot submit.
So that order can go also.
That would be our prayer.
That order can go.
Investigation
Not-
going on, lordship.
Do you need or no? You don't need.
Lordship, I cannot.
Learned counsel for the state states that the MOU entered between the parties. He states that you have reservation to the MOU.
Lordship, lordship. Lordship, no. Settlement.
No, then why are you investigating? Then the investigation is over if you don't have any issue against the settlement. If there's no issue against the settlement, let us close this case.
MOU exception we irritate.
Learned counsel for the, he seems to be very happy. Learned counsel for the respondent states that he shall file exception. You want to take exception? States that he shall file his report and raises preliminary objection to the MOU. And further states that since the investigation is still under process, is still underway, the culpability of the culpability of the accused persons cannot be resorted to by merely entering into MOU and making it a purely civil matter. Full stop. He seeks and is granted further. How much time to file your report? 4 weeks time to file the report. Bringing on record the further report. That's all. Report. Same order in all the other.
Hello, the next one, visions. Now, so far as Mr. Vaibhav Gupta is concerned,
Yes.
he's obtained an order of no coercive action here.
Yes.
And 19, he's filed application for anticipatory.
That is not pressing.
As of that was already kept in abeyance even in the previous set. Maybe
Item 19, the application is not pressed at this stage. Let this be listed along with sorts.
the interim order of no coercive action.
Interim orders, my lords.
In order granted earlier by this court, by an order dated so and so, shall remain in force for a further period of till 31st of February. Interim order of no coercive action.
Actually, kindly record my permanent protection.
No coercive action.
Grateful, my lords.
Because in the very nature of things,
You file an application, Mr.
But
Kabir,
difficulty-
file a cancellation.
One of the difficulty is.
Bail has been granted,
Application till I am a party in the proceeding.
so not here, the cancellation.
No, that I understand.
Cancellation, yeah.
Also.
Yeah.
But I'm saying that so far as no coercive action is concerned, Manoj is well aware, position that has been laid down by.
They themselves are saying they don't need
No, that does not.
custodial
The
investigation.
greatest of
We are not
respect,
saying
If
the,
the parties to a proceeding consent to an illegal order does not mean the court will pass that order.
that's why I'm not passing it. I'm not giving any observation.
My lord.
So
No,
let,
the difficulty is that interim order in the nature of no coercive steps is something the Supreme Court is repeatedly deprecating.
deprecating, I
Is
know.
Sending back to the High
I-
Court saying, please consider it after reading here. So in this background, Manoj, I'm saying this order may not be passed.
Learned, this may call line item, learned counsel for the applicant opposes the no coercive order which had been passed by this court. ये 19 में नहीं है, ये first वाले ही में सब कुछ है. And that gets copied in the second one. 19 is only, he is not pressing the application, the same shall be listed along with the other items. That's it.
And also we pass an order directing it to be tagged. All of these can be tagged.
All tagged. All three matters shall be tagged along.
They are not tagged.
Good.
All these matters shall be tagged along. These are 6, 7. Okay, 6, 7, right?
Yes, my lord. 6 and 7, my lord.
All the three matters shall be listed together. 5, 6, 7. 19, 19 also. 5, 6, 7 and 19. 5, 6, 7, 19. This is appeal सबका डाल देना.
I am so deeply obliged, my lords. I am deeply grateful.
Yes, let's finish it. Where is Mr. Mishra? Mr. Mishra, come. Let's finish the matters. Yes, Mr. Mishra, what is the?
Actually, just now here, let it be passed over some point. I will make up a sir. Yes.
Yes, what are we?
His application is pending, he is stating, I will check in the internet and I will make a proposal.
Yes.
Within
Passover.
short passover.
Short passover. Passover.
Lordship, let it be disposed of because I have got it, it is pending. So same order can be passed.
Application is pending.
Yes.
All right. So you'll decide the application.
Lord.
All right. The petitioner is aggrieved by the inaction of the respondent in not granting him electricity connection for his residential accommodation situated at survey number 167/P, area 400 square meters, situated at Kadilganj village, Ferrarganj Tehsil, South Andaman. Full stop. It is a case of the petitioner that he is the occupier of the aforementioned government land and has constructed a residential accommodation.
That liberty will be granted to us, not the queen, to check this, because I have already shown on Thursday, Lordship, on how.
No, that is you. Where have I passed orders where you have to give it? I've always left it to you. Accommodation thereon. Full stop. He states that he has been staying on the above said accommodation, above said land with his family. Full stop. He applied for a city connection by application dated 10/11/24. 10/1/24. Full stop. However, no electricity connection has been granted to him. Full stop. It is a submission. उसको छोड़ दो उसके कर दो. Learned counsel for the respondents states that he is ready and willing to decide petitioner's application dated 10/1/24. Full stop. In view of the statement made by the counsel for the party, this court directs the respondent to decide petitioner's application dated 10/1/2024 within a period of 4 weeks after affording an opportunity of personal hearing to the petitioner or any other stakeholder by way of a speaking order. Full stop. उसके बाद वो जो एक है ना paragraph, it is clarified. Good. With the above direction, the presented petition is dismissed. कर रहे हैं अभी आइटम 8 हुआ है 9 इंडिविजुअली करना होगा.
Item 9 Lord the ban, of time to file my.
Why? What is the difficulty in this?
Lordship, yes, surface.
Report you have already filed.
Liberty was given to me. Can you see this order? My lord, liberty was given to me to file a first application after getting a document. I filed now this application. I got a document. I filed a petition.
I have the document to show that. So let me file the revised order. Let the extension be granted.
And last question.
Why he has not filed this application along with the application? Why he has not filed this?
Liberty was given to me.
Why he has not?
Just a minute, Mr. Mishra.
Liberty was given to me to file a document. Now I got a document. I filed it.
This is the way to file it.
My document I enclosed the petition. The document is an identity card.
This order, have you filed it?
I don't know.
Why?
Because liberty was given to me to get those documents. I got this document. I filed a petition.
Sir,
I got document.
you have to place this order on record.
Nothing can be suppressed.
Suppression is there, Lordship. Let me find.
Because last time, liberty was given to the petitioner to obtain the document and file accordingly to file application. Now I got the document. The election ID card page number, my lord, page number 15 of the petition. I got election ID card. Now I filed the petition.
Just a minute, let me hear him out. Yes, yes, tell me.
Earlier this was with me.
Page number
Page number 50.
50.
Yes, 1-5.
P. Krishnamurthy, huh? Election Commission.
After getting this document, I filed the petition. The only electoral earlier I could not get the document. It was not there. So they rejected my application. Only this ground.
You consider his application.
Lordship, let me file it.
Why reply?
Because I have other documents
Show
which
me.
he has suppressed because this one.
Show me what document. What document has he suppressed? Show me.
Lordship, let me file it.
No, sir, plus show me.
Lordship,
Why
am
should
saying
I
that
unnecessarily?
I will be permitted.
No, why should I, other matters I'm passing an order, why should I give him, give you a opportunity in this case? Why do you want to oppose it? Show me what is that. I'll pass an order. I'll pass an order directing you to give him a city connection. Yes, what is it?
Lordship, in March 25,
Yes,
house was not constructed.
All
He
right.
has applied.
all right.
I could not get the report because the
Yes.
court, as usual, passing the order.
Yes,
And thereafter, I have asked my officer to verify it. He went there. It was found that building is under
see,
construction. No, why?
last
No, I
time
think.
you had rejected it, not on that ground, you had rejected it. Please see.
That application, that earlier round of litigation, Lordship.
Sir, whatever it is.
That was earlier round
You
of
can't keep
litigation.
making other grounds. All the grounds, when you pass an order,
That report was.
when you pass an order, all grounds should be mentioned. Where is that ground? Where is that ground in that order?
Lordship, can I get?
Yes. Wiring and earthing, all has been done.
After we are rejected.
Yes, yes, but today you are obviously.
Today, Lordship, when we have rejected earlier.
All right,
Once
take down.
again, he has to file a fresh application.
Take down. The petitioner has preferred the present writ petition, seeking a direction. I will record all your submissions.
Writ petition is not maintainable, writ petition has to be dismissed.
Not maintainable, why, Mr. Why not?
Because he has suppressed the material thing.
What material thing? What
Earlier
material?
round of litigation, he has not said anything in the writ petition. Just right now, he is submitting this document because.
There is nothing in there.
But he has to file
Take
it.
down. The petitioner has preferred the present writ petition, seeking a direction upon the respondent authorities to provide LCT connection to his dwelling house situated on government revenue land bearing survey number 260, measuring an area of 160 square meters at Lambaline village under Sri Vijayapuram Tehsil,
Lordship,
district South Andaman.
point number 2 may kindly receive.
Full stop.
We have mentioned it in this order also. Point
It is
number
the
two.
case of the petitioner. It is the
Point
case of the
number two.
petitioner that he has been in occupation of the said government revenue land as an encroacher since 1978, but prior to 1993. Full stop. The petitioner submitted an application for electricity connection on 12/6/2025. Full stop. It is his submission that by communication dated 9/5/2023, comma, उसको हटा दो. A report, full stop. A report has been filed on behalf of the respondents. Full stop. It states. It is stated therein that the petitioner's application for electricity connection is under process. It is also pointed out that by letter dated 17/6/2025, confirmation was sought from the Tehsildar Vijayapuram regarding the settled possession of the petitioner. Full stop. The Tehsildar, however, via the communication dated 26/2025 stated that the Revenue Department strongly objects to encroachment on government land and to the grant of electricity connection to such encroachers, and that the electricity department would be solely responsible if such connections are granted. Full stop. Further, upon inspection conducted on 11/7/2025, it was noted that the petitioner had not completed the construction of his house, and that the internal wiring and earthing was also incomplete. Full stop. The petitioner had filed objections to the said report and has annexed photographs to demonstrate that the construction of his dwelling unit has been completed and that the wiring and earthing works have been duly carried out. Full stop. This court has learned counsel for the respondent. Learned counsel for the respondent states that the presented petition is not maintainable since the petitioner has withheld material facts at the time of filing of the presented petition. Full stop. He states that the presented petition shall be dismissed on this ground. Full stop. This court has heard
And
the
moreover, this is not a dwelling house, but already
learned
bricks
counsel
and all is
learned
lying
counsel
there. Nobody is
for
staying
learned
there.
counsel for the respondent further states that it is not a dwelling unit. Full stop. This court has heard the argument advanced by the counsel for the parties and carefully produced the materials on record. Full stop. As per the report submitted by the respondents, the petitioner's application for electricity connection is still under process. Full stop. The two objections raised by the respondent, lack of cooperation from the concerned Tehsildar in confirming that the petitioner is in settled possession, and second, the alleged incompleteness of construction and wiring as per the inspection dated wiring and earthing as per inspection dated 11/7/2025. First, the issue whether a no objection certificate as envisaged under clause 5.0 of the JERC regulation 2018, is no longer is a mandatory precondition for grant of electricity connection is no longer res integra. Full stop. A coordinate bench of this court in WPA number 261 of 2025 by order dated 11/7/2025 held as follow. This was Krishna Rao ka order paragraph. Full stop. It is in view of the above settled position, the objection regarding non-compliance of clause 5.30 of the JERC regulation 2018 cannot be sustained. Full stop. A no objection certificate from the concerned revenue department is not required. The petitioner has placed on record his Aadhaar card, which records his address as ward number 9. Election card, which records his address as ward number 9, near Ram Temple, Lambeline, Jumli Ghat, Vijayapuram Tehsil, Shri Vijayapuram Tehsil, South Andaman. Since the election card has been issued by the government authority recognizing his residence at the premises, it is clear that the petitioner is in settled possession of the land. Full stop. Accordingly, the respondents are directed to conduct a fresh inspection of the petitioner's premises and if found safe for supply of electricity, process and grant electricity connection within a period of 4 weeks. Within a period of 4 weeks from the date of receipt of this order, subject to the petitioner's compliance with all other requisite formalities as prescribed under the law. Full stop. It is clarified that in view of the Aadhaar card, the petitioner's election card, the petitioner's settled possession stands established and no further clarification from the revenue department is required. With the above direction, the present writ petition is disposed of.
Blair.
Mr. Mishra, you jump before the order is passed. Yes.
I'm sorry. Application is pending.
So we'll give a direction then. ये जो पहला वाला है ना item 8 का order, same order कर लेना survey number चाहे. ये इसको हटाओ. पिछला वाला मैटर का. Disposed. What is the status?
Yeah, Lordship, still pending.
Same.
Same.
Same कर लेना इसको.
That's it.
Survey number chief. Yes.
Same, Lord, pending, which is pending.
422.
423.
423.
It is pending, Lord.
Pending same order as item 8.
Lordship, item number 13, already there was an electric connection in the name.
Who's appearing? Item
Rosen
10.
Bibi.
Who's appearing?
He is appearing, Rosen Bibi.
Mr. Thakur.
No, in the same premises. But she has not paid the electricity charge for last 8 months, so we have disconnected it.
All right.
This
File.
application is not at all
My
mentioned.
client was not. My client is Bobita Hira. He is saying about some BB.
Yes, fine.
Your
Premises.
lordship
All right,
different.
let them file their
Payment
report.
may be saved, but person is different. Applicant is different.
Acha, house will be different.
House is different. Then
No, house will.
Learned counsel for the petitioner has preferred the
This is
present.
the report. I have the report.
I disputed.
All right, fine.
Strictly.
Let him file his
I
reply.
told the Bobita Hira.
All right, sir, all understood. You have disputed.
Your lordship.
I got it. Learned, the petitioner is agreed by the inaction of the respondent in not granting her electricity connection for her residential accommodation situated at serial number 60, survey number 609, comma, area 240 square meters, comma, situated at Namungar village, comma, Ferrarganj, Tehsil, comma, South Andaman. It is the case of the petitioner that she is the occupier of the aforementioned government land and has constructed a dwelling unit, full stop. She has been staying with her family, full stop. She applied for electricity connection via application dated 18/7/2025, full stop. Till date, no electricity connection has been granted to her, full stop. Learned counsel for the respondent states that he seeks and is granted 2 weeks time to file his report, reply to the reply.
I have the report.
You have?
Report is about Rosan BB, not Bobita Hira.
Here, encroachment land also sold. by the-
Learned counsel for the respondent has filed his report. Learned counsel for the petitioner seeks and is granted
Rosan BB.
2 weeks time to file his reply to the said report.
Lordship,
Report
can I
is,
get back that, so that I can supply a copy to.
Why?
so that's why you filed it.
You look the same.
Learned counsel for the respondent seeks and is granted 2 weeks time to file his report. Reply to the same, if any, within 1 week thereafter, list before the next available circuit time.
Have you authorized?
Lordship, it is pending.
So one person doesn't pay, then the city gets connection, different person with a different name comes, tries to get the next.
Your Honor, I am not.
That is the
Report
difficulty.
is defective.
We all know what is defective. Yes, madam.
His application is pending, Lordship. Let's see what will be.
Item 8,
Application
this one.
Lordship, asked my junior boy to take the inspection from his client with regard to house.
Yes, yes.
Residential house or
There was nothing there. Yes, tell me.
this is the.
I know. What?
It includes, so annexure B4,
Yes, yes.
annexure B4 is the order by the way of which they have rejected my application.
P4, which page?
Page number 15.
Page number?
15,
Yes.
in which they have stated that as per my date of birth.
Page number 50,
Five,
it's not there.
50.
It's only till 49. See?
I'm having the additional. I'm very permitted.
So you file learned counsel
Supplementary.
supplementary. Learned counsel for the petitioner seeks and is granted. Learned counsel for the petitioner states that he has filed a writ petition annexing
Order dated
order dated
14 June 2025.
order dated 14 June 2025. The same is missing from the writ petition. He seeks and is granted liberty to place the same on record. Next available survey. Item 16, 17. This is item 17 or 16? Yes. Application pending.
Lordship, service is not available. I do not know the.
Learned counsel for the petitioner states that the service is not complete. She prays for the next circuit. Let this matter be listed before the next one. Yes.
He has not submitted the idea. He has not submitted the idea.
But it's not all.
So what do I do?
Let it be in the next circuit.
I find I need to, this page number 13.
You have not
That is
submitted.
standard.
You have not submitted.
Yes.
Let me mail.
इसको learned उसमें एक line add कर दो फिर. He'll submit the ID proof.
Let him submit through.
See, there's other.
In the writ petition, you can file. You have to submit before the authority, sir.
You file it and then you try it next time, sir. At the request of the learned counsel of petitioner, let this matter be listed before the next available, sir.
I will report your.
18 who's there? None for the petitioner. In the interest of justice, adverse orders are deferred. Let's before the next available second.
So, Blair. Lordship, I would like to mention item number.
Yes.
4.
4.
Lordship,
4, you were not here. I kept asking Mr.
explain. One matter was fixed before court number 1. I was just there. Item number 4.
I know item number 4, that NG, that appeal
yes.
which has been filed.
Lordship, but they are disputing.
Confusion between the date and when did you file it and all that.
Similar point they will take before the lieutenant governor also.
I have not done anything. There's no order.
No order has been passed. Lordship, what I am praying, Lordship.
You are only asking for the demolition of that 20, that order which has been passed.
Lordship.
You are seeking implementation of the order, but they have gone in challenge to the LG. You are saying
After the writ petition.
this has a checkered history.
No,
Many
Lord,
rounds of litigations?
This is, they are saying that they have not received it, but they have produced the document, the municipal authority has produced the document.
Miss Nag is not here.
I am praying that just let
Next
it, let
circuit.
her signature be sent to GUKD.
Hey, why?
Report the girl.
Mishra,
That's it, next circuit is on
Next circuit.
27th October, that is the difficulty.
that's okay. Next.
Or else I am.
I don't want to pass negative orders. Enjoy Durga Puja by you.
Lordship, sir. I am sorry.
In 20, I was 24, I think 21, I was 24.
As per the petitioner. And seeking their matter will listed before the exam.
Next, sir.
As per the response.
At the request of the party, you are for the petition.
For the petition.
At the request of the petitioner, let this matter be listed before the next available sir. Which matter was this? Item number?
2021, I did 22, I was 25.
Who's there in 22? Yes, Ms. Pavita. You are for the petitioner? Petitioner? Learned counsel for the petitioner, proxy counsel for the petitioner, Ms. So and so appears and states that the main arguing counsel is in personal difficulty. She prays for an adjournment. Let this matter be listed before the next available circuit. Yes, who was supposed to file? You are the private respondent. Affidavit in opposition used by the private respondent is taken on record. All right, उसमें एक line add कर देना. Learned counsel for the petitioner seeks and is granted one last opportunity to file her reply to the affidavit in opposition filed by the private respondent. List before the next available circuit bench.
Extension of time to file my affidavit. Actually, it's for the petition.
Learned counsel for the administration seeks and is granted further 2 weeks time to file his affidavit in opposition.
Yes.
Affidavit in opposition, reply to the same if any within 1 week thereafter, list before the next available circuit. All right. All of you have a wonderful vacation. Thank you.